as we think about how we as lawyers represent our clients and work with our clients, today's panel really is instructive in that regard, and we hope that this will provide you some useful advice. And we wanted this to be interactive. We hope each of you in the audience, if you have questions, think about them, and then we'll leave time at the end of our panel for questions. Our topic today has a pretty long description in the materials, and we emphasize the Volkswagen case. Well, we encourage you to look at the materials we've included for the program about Volkswagen, but we're not really going to touch so much on that topic today. There's no doubt that Volkswagen is a great cautionary tale, but we would like to kind of move to these hypotheticals we think will be useful in our discussion, so we'll do that today. There are materials, though, that we encourage you to look at that are useful about the FCPA guidance that the Department of Justice has issued, other instructions on corporate compliance programs and how they're implemented. So there's plenty of materials that we think are useful to look at, but it was the unanimous decision of this panel that we moved to hypotheticals and not at late in the day on Friday afternoon move to a lot of presentations on the content of these materials that are easily read by you. So we'll do that. To my right, I'm delighted to introduce Norm Brothers, who's the UPS's General Counsel and Corporate Secretary. Norm leads the global legal and audit, compliance and public affairs and privacy functions at UPS. He previously served as the company's Vice President and Deputy General Counsel. Norm joined the management committee some years ago. Prior to joining UPS, Norm served on active duty as a captain in the U.S. Army. He was a military prosecutor in the Judge Advocate General's Corps, and he also practiced with the international law firm here in Atlanta, King & Spalding, where he focused on commercial and tort litigation. Norm is a graduate of Emory University. To Norm's right is Sally Yates, known to all of us, former Deputy Attorney General, and I don't know whether this microphone is active or not, but I'm as close as I can get to it without hugging it. The former Deputy Attorney General of the United States, and as a partner currently at King & Spalding in Special Matters and Government Investigations Practice. We all know that Sally was the #2 official at the Department of Justice, where she supervised and coordinated the work of the department's then 113,000 employees. She's a fellow of the American College of Trial Attorneys, and she specializes, again, in independent investigations for public and private organizations. I had the pleasure of working with Sally some years ago when I was United States Attorney here in Atlanta, when she was really early in her career, and so it's with great pride that I'm on the same panel with you today, Sally. Sally is also credentialed very well as a double dog, an undergraduate from the University of Georgia, and also her law degree. On the other table is Ann Tompkins, who's a partner in the law firm Cadwalader. She is located in Charlotte, North Carolina, and she also practices in Washington, D.C. Her practice focuses on representing companies and financial institutions, as well as their officers and directors in criminal, civil, and administrative investigations. Ann also was a former United States Attorney in the Western District of North Carolina from April 2010 to March 2015. Ann also served earlier, as did Sally, as an Assistant United States Attorney in the Western District of North Carolina. And Ann and Sally both are adjunct professors, Ann at the University of North Carolina at Charlotte, and then Sally at Georgetown University. On the far end of our other table is Ron Swartz, and we're delighted to have Ron here, and Deloitte is one of our sponsors of our program, and we thank you, Ron, for that. Ron is a partner in the Atlanta office of Deloitte Financial Advisory Services, Forensic and Dispute Services Practice. He specializes in providing forensic investigations, including investigations under the Foreign Corrupt Practices Act and the False Claims Act. Ron is distinguished by being both a U.S. and Canadian citizen, so maybe we could get Ron's help working out things with Canada. And he has conducted numerous forensic investigations and litigation support in both countries. He has extensive experience consulting with counsel and their clients and performing forensic investigations related to financial statement fraud. And I recently had an experience where Ron, your services would have been extremely useful, and I look forward to being in touch with you after this program. He's a graduate of York University in Toronto. What we want to do now, and I'm looking around for someone. I have a little trouble seeing the PowerPoint, so what I might do is employ you, if I could, Brian, and flicking the slides for me, if you don't mind. Thank you. What I'm going to do now is you should each have a paper copy of the hypotheticals, and what I'm going to do now is walk through the hypotheticals, and then we'll move to some questions with our panel. A year ago, you were named the General Counsel of publicly traded Bulldog Oil Company. Bulldog Oil is incorporated and headquartered in the United States, but has significant operations in Saudi Arabia and Russia. 2 months ago, Bulldog Oil began expanding its operations into Libya. 2 weeks ago, an unnamed employee called the company's ethics hotline and reported that the manager in charge of setting up the Libyan operations provided payments to mid-level Libyan government officials to obtain drilling rights in the lucrative Sarir oil field. The manager was selected to manage the Libyan operations launch after he successfully set up operations in Russia and Saudi Arabia. According to the unnamed employee, when he confronted the manager about these payments, the manager responded, "That's just the way it's done, or how it's done at Bulldog Oil." These hypotheticals are taken from real-life situations, and so what I want to do now is sort of engage the panel in some discussion about these hypotheticals. And each of you, Norm Brothers from UPS, each of you come to these things from a different perspective. So the first question really out of the box is, what stakeholders within Bulldog Oil should be notified at this point in time, or is it too early? But there are a number of opportunities here: the Board of Directors, the Audit Committee, Compliance Committee, others. And again, in all of these hypotheticals, we have to think about who is the client, and quite challenging in major corporations to assess who that is. Let me start with you, Norm, on this one.
Yeah, I'll just maybe talk about a couple of things that would come to mind in terms of first steps if a situation like this arose. I mean, the first thing that I would think about is there conduct that's ongoing that would need to be stopped, immediately. So that would be, I think, my first reaction. Is there something ongoing, some behavior that needs to be stopped, so that we could then focus on investigating the issue and trying to understand, what happened. The other thing, in terms of investigation, because clearly that's the next thing, right, is understanding the facts to the extent, that we can. And I would say that because of the nature of this, it would probably also raise a question of whether we could do it internally versus bringing in outside help, because it strikes me that this is one that you'd want to make sure you had some independence that would go along with whatever investigation, so that you wouldn't have to do it twice. And then the other thing that I would say too is, because you have the whistleblower component, so it needs to be managed from that perspective. So I think I'd also try to very quickly try to engage. I know it's identified as an anonymous person on the through the helpline or however it came in, but to try to engage that person, to try to start maybe with understanding everything that you can and exhaust the knowledge of the person who raises the issue, and then also try to engage them so that they don't feel the need maybe initially to go somewhere else with the information, to allow us time to investigate. So those are just things sort of off the top of my head about how I might start thinking about the problem.
Sally?
Yeah, well, this company is, to state the obvious here, operating in some pretty risky countries. And so you have to hope that they have some strong compliance procedures in place already, both in terms of FCPA, but also from a sanction standpoint, that they've got some pretty good procedures set up. Certainly, if the GC doesn't know about it, the GC needs to know about it right away, so that you can then engage in the kind of analysis that Norm just identified there, in terms of how you're going to deal with it internally before you make decisions about who you would go to externally. And from my perspective, I don't think you know enough yet to be going to the board about it. I think you need to do some level of internal investigation, even if it's just a preliminary one first. But then certainly starting, whether it's with, if you have a compliance committee or audit committee, starting with that before even going to the full board.
And what I would say too is we would probably go to the chair of the audit committee. So if you were at a point where you at least need to give a heads up to the board, wouldn't call a meeting or sort of bring the whole committee together, but probably a phone call to the, after I talk to the CEO, talk to the chair of the audit committee.
And these two countries, and before we go to Ann for comments, of these three countries, Saudi Arabia, Russia, Libya, are all, to your point, Sally, all countries with high incidence of corruption. Is that correct?
That's right.
Ann?
Well, I was happy to hear Norm say that you want to think about getting independent outside counsel. We all in the room like to hear that. But I do think that it is important, and Sally touched on this, to triage the situation before before you go out, even reporting to the board, much less we'll talk in a minute about SEC or DOJ. So I think that triage period of wrapping your arms around what your issues are, how widespread, and especially given the nature of the places in which the conduct is alleged to have taken place. You really need to spend some amount of time. I think the threading the needle is how much time do you spend in that triage period before you really go forward. So I think that's the fact-specific kind of weighing that you have to do each time.
Yeah, and I'm going to definitely represent the external auditors here on this panel because don't ever forget about your external auditors, because this is something that would be of definite interest, right? Given the potential magnitude, like, look, we don't know if there's merit to this, absolutely, but if there was merit to it, it opens up a whole slew of questions. You know, what is the financial impact? Is there financial statement implications? Are there FAS 5 accrual impacts that you'd have to measure and potentially disclose? Are there controls, right? Material weakness or significant deficiencies in the controls that the auditors would have to think about, the company would certainly have to think about. And as auditors, when you have allegations like this and you talk about setting up an investigation team, whether it be internally or externally, going to a independent third party to lead this investigation, as auditors of the company, we would be relying on your findings, right? We would be relying on the procedures that you're employing, the team, and ultimately your findings. So we early on would want to feel comfortable with how the approach is, who you've engaged to lead the investigation, even look at the work plan, and have a potential opportunity to comment on the work plan with respect to who you're interviewing. Are you doing discovery? What custodians are you collecting? What key term searches are you using? Not to micromanage or take over the investigation, but to ensure as the external auditors that we're comfortable enough that we can ultimately rely on the results.
So in my experience in dealing with the external auditors, it is a bit of a delicate dance that you engage in, because you have this balance between disclosing too much information, and defining that is very difficult. But I do think it's a process that you should engage in, and it's quite challenging when you have information that might be damaging to the corporation.
And if you don't do it early, like if you engage the external accounting firm towards the middle or end, that could cause problems, because if they're second guessing things, it requires potentially for you to redo things or potentially expand the investigation that wasn't originally contemplated, which causes not only delays but additional costs.
Yeah, the other thing that comes to mind is the goodwill, credibility that you build between your internal auditor,
Absolutely.
your function, and your legal function, and your audit and your compliance function, and your accounting function as well. You hope that you work on that well in advance of having sort of a crisis or an issue like this, so that you can have some goodwill and credibility. It goes both ways, so that there can be some trust in terms of how the maybe investigation gets set up, but also when it's time to provide those updates on how things are going, you can also be assured that information that's shared isn't going to be sort of misused or documented in a way that will cause problems later.
Well, it sounds like those people, that's a great point, those people should know one another before you have an episode or incident. Mm-hmm. And so, Norm, one thing you said earlier is that you think maybe this one's a little too early to go to the board on, and needs to be more developed, right? Is that what you were thinking?
Yeah, I think so. I think it seemed to be some consensus on the panel that it is quite early to, to raise issues. Well, I think you do have to balance, though. Information flows so quickly these days. I mean, you're on this sort of 24/7 news cycle. Can't even have a lawsuit filed against you these days without it sort of showing up on Bloomberg. So I think with the whistleblower involved, you have to weigh some of those factors, too, because it could be that that a heads up would be appropriate, like as I said, perhaps to the chair of the committee, just to let them know that this was going, so there wouldn't be a surprise if, God forbid, it became public, which it could do.
One fact in the hypo that may or may not be interesting, but that the whistleblower. It's a 2-week time frame between when the whistleblower called the hotline and when it got reported up the chain. So you're already, depending on how fast moving this issue is, you're already 2 weeks into it when you've just begun to take first steps. So I think those are the sorts of things you have to keep in mind in pushing the thing forward.
So somebody in filling the places you've been, I mean, Attorney General, Deputy Attorney General Sally, and U.S. Attorney, both you and Ann, and your responsibilities. Are you looking for, in this hypothetical, sort of looking from the outside in, should there have been is there a need for disciplinary action the company to take right now? Seems like they have somewhat limited facts. They've only got the whistleblower report. They haven't done an investigation yet. So there's always, hindsight's always 20/20, but the lens you're looking at it through, advising corporations today, but also the other lens you used to look at it through, is it too early for disciplinary action against the manager in Libya?
I'll just do quickly, Sally, I'm so much in my defense mode right now, it's hard for me to go back in. But so I would want to go slowly. I don't want to jump to firing people, notwithstanding the Yates memo, but because I want to know, I think it's important to know the facts. And so here in this particular hypothetical, I think there's a lot of smoke and the flames are probably pretty high just based on our facts. But I do think it's important to perhaps isolate the manager, have them step back from responsibilities so that, when you're looking back, you say, look, what we want to do is freeze everything while we find out what's going on and take action when you have enough steps. So, Sally.
No, I would agree with that. You certainly don't have enough to fire him yet. But if this is borne out, I think it's the no-brainer there that you can't, that this is a person who needs to be fired. But I also agree with Ann, you also don't want to just leave him in place to potentially keep doing what you've now been put on notice, and particularly if it's 2 weeks into it, you've been put on notice that was not an isolated incident, but rather his declaration that this is how the company does business. That's going to be a dicey sort of step to take, though. You've got to decide, and that's why I sort of agree getting an outside firm in to investigate very quickly is going to be important, so you can make decisions from an investigative standpoint about what you want to do and what evidence you might lose if you then go to him immediately, for example, to suspend him. You don't want him continuing in the position, but yet you don't want to lose the opportunity to gather valuable evidence as well.
Yeah, that's a great point.
And Joe, back to your initial point, with being a U.S. attorney looking back at it, the government is going to look hard at first steps, because that is part of the culture of the organization and the culture of compliance. And so how you act immediately is going to weigh heavily. So you have to, when you're acting, even though we don't know whether we're going to ever disclose at this point, you still have to act as if someone will be watching or someone will be judging whether you are acting in a way that's consistent with a strong compliance program.
And Sally's point about that interview of the potential bad actor, it's so important, I think, to try to get as much information as you can, perhaps before you have that first interview. You might not have an opportunity to do it twice. You take a person out, you terminate them, and you might not have a chance to do it ever. And there's so much that can be done sort of quickly, I would say, through email searches, document reviews, maybe exhausting the knowledge of the whistleblower or people surrounding the manager, so that when you do go in quickly, but when you go in to do that interview, you're sort of loaded for bear, so that you can actually get as much information as possible. And also, it can be more effective if you can confront them with some of the documentation, and you may be more likely to get the full story, which is ultimately what you need to be able to then take the right corrective action.
And we had a FCP investigation in Turkey that literally mirrored the facts of this hypothetical. And one additional fact is based on email reviews and interviews, is there were about 6 or 7 people who reported to the country manager that had knowledge. They weren't complicit, they weren't necessarily, maybe one or two were assisting, but 5, knew about it, but just didn't do anything about it and knew they had an obligation to report it. And the question then becomes, the company absolutely wanted to terminate all of them. The question becomes the timing, right? Do we want to keep them around because we're still continuing the investigation? We're going to have many more questions. We haven't even gotten through all the emails. If we have additional questions and the company's now terminated these employees, will we have access to them again to ask detailed questions? So that whole timing becomes interesting as well.
Yeah, document preservation too. I mean, hopefully people have centralized, email servers, but there have been times, say at our company, where in certain locations outside of the U.S., you'd have more store and forward kinds of situations where maybe emails or documents would be on laptops. It's another thing, you don't want to give people kind of a heads up that they're under investigation, give them an opportunity to destroy data. So you need to be thinking about that too. How are you going to collect this stuff in a way that you can ensure that once they understand that they're sort of the target, that they won't take steps to destroy information.
So let me move now to sort of the really difficult question. And I know years ago I believed in preemption. I'm an advocate of kind of getting in early to I visited with Sally on a case many years ago and said, we have a problem. We don't know what the nature of the problem is, but we're going to look at it and we'll come back and report to you about it. Those were in the old days. Things were much more complicated today and much more sophisticated in our world, to your point. And with communications being what they are, timing is really critical, and hindsight is always going to be 20/20. But do you self-disclose to the SEC and DOJ at this point in time? Why or why not? And is it really, Norm? Is it too early still? I mean, to go that route? Do you think, Norm? Okay.
Yeah, I mean, it still feels to me like there are a lot of questions that need to be answered. Sometimes the way I think about it as well, you would do everything that you would do in connection with a self-disclosure as part of your internal investigation. I'm just not sure you know enough yet to make that call. Again, I mentioned the whistleblower factor. I think one thing to consider is how likely is it that the whistleblower might move before you do, because I think you certainly would prefer to be the first mover and to sort of have that conversation with the DOJ or the SEC before the whistleblower does. So that is certainly a complicating factor here. But I certainly would like to learn more, before going in. But there are other factors involved.
Any comments from anybody? Thank you, Norm.
Look, I think that you hit on it, Joe, when you put this question out, is that when you disclose, it doesn't have to be everything. Your disclosure can be, we think there might be something, but we don't know. And here are the steps that we've gone to put into place. While we make that determination, we'll be back in touch. So there are times where you might want to put that marker down, but then quantify it accurately about what you do and don't know. Especially if there is, as in our hypothetical, you've got a whistleblower, you've got a situation that leads to you maybe to be leaning towards the fact that something might have happened. So which I think just in considering disclosure, you don't have it in your mind that disclosure has to be the full picture. Disclosure can be, we are looking, and here are the steps we've taken.
Yeah, I mean, I would agree that you don't have nearly enough right now to go and disclose, because for all you know, this is some nut who called the hotline, and there's not anything to this. And then, you're going to DOJ and SEC, and people are then rooting around in your business. I don't think you go yet, but there are things that you can do to determine whether there's any corroborating evidence out there that this did in fact occur. And to Ann's point, when I was at the department, we certainly did encourage companies to come in early before they necessarily knew everything. And there are advantages to corporations in doing that as well. For one thing, you get to pick where you go. Oftentimes matters can be venued in a number of different offices. And so you can choose which U.S. Attorney's Office, or you can choose to go to the Criminal Division or the Department of Justice. You can do what some might call a little forum shopping there in terms of where you might want to disclose. And there's also the added benefit that DOJ has way too much to do and not enough resources to be able to do it with. And so if you go to them early, before you necessarily know everything, oftentimes the department will sit tight while you do your investigation. And then they're not going to just necessarily accept that, but they're not going to be out there rooting around and talking to your employees before you are. So you also can potentially get that advantage as well, to be able to figure out for yourself what's going on first. So agree, not nearly enough now, but I don't think you need to wait till you can tie it up in a big bow either, to take it to the department. There's some place before that.
Absolutely, thank you. And when I moved, I don't, my clicker is not with me, and I may have lost my,
I'm gonna
oh,
try
you
to
got
do
it. Okay,
this.
you're in charge.
How's
Okay.
that?
Thank you.
I
So-
do that right?
Move to the next hypothetical
more?
page.
All
And
right.
so, acting on the information you collected during the preliminary investigation, you order an audit of all payments authorized by the manager during his 7-year tenure with Bulldog Oil. Those records show several suspicious payments to individuals connected with the Kremlin, House of Saud in 2012, 2014, and 2016. Questions are posed. How does this new information change the strategy, scope of the internal investigation? And once the investigation is complete, what steps will you put in place to mitigate the risk that this type of misconduct may occur again in the future? And I thought I might ask Norm, you and Ann about how this new information changes the strategy and the scope of the internal investigation. After all, I'm sitting around by the phone, Norm, hoping that I'll get a call. But anyway, but the point is, there is the debate, isn't it? Who conducts the investigation is one issue you're evaluating, correct?
Yes, but I think your point about scope is what this really indicates, is that as often happens with these, once you start to pull, one thread, other, issues come up, and then the scope of the investigation will expand, and you'll have an obligation to understand, what's going on as it relates to these other issues. So that's the first thing that jumps into my head, is that you've now got other issues, other jurisdictions that you need to consider, and evaluate how you're going to look into those matters as well.
And now you have additional information. You have a potential paper trail. So you have that corroborating evidence that you're looking at. You've got more than just a whistleblower. And you have Russia. So Russia is one of the 4 top countries for FCPA violations. And so you're now, I think that puts you into a different zone. And I think this also then brings up the scope issue. So what will DOJ want you to do at this point? Or they want you to expand your investigation into multiple countries. And when I read the hypo, it reminded me of Leslie Caldwell's "boil the ocean" comment, and so I think that may push you towards having a conversation with DOJ about scope.
And so, Ron, when I see the word audit, I think about Ron Swartz, right?
Yeah.
So I'm thinking about comments that have been made. We have something going on in Libya. Your companies around the world, and I assume deployment is not a problem, but how do you capture all this information, all these records?
Right.
We're talking about, a place that may not have, you're getting in out of a country, what do you do? There are all kinds of other issues about gathering information around the world that we won't have time to get into today probably, but what are some of the things you're thinking about from your role?
Right, it's always a nightmare situation, right? Because if there's merit to the allegations, let's say in Libya, then it always begs the question: what else could this person have done? And this person used to head up 2 high-risk countries with Saudi Arabia and Russia, and was he or she doing the same thing there? Which clearly, from these facts, it looks like he is. So then it begs the question, what else is going on? So you'd want to look, obviously you're going to look at this person's emails pretty extensively, but you're also going to look at financial information. So has this person repped and warrant financial information in countries that he or she has managed? What journal entries did they approve into the books and records of the company? What transactions did they approve, whether it be wire transfers or other types of transactions? You'd want to look at that extensively. And also, who else might have known that this was going on? Who did this person report to? And did they have knowledge of these transactions and some of the allegations that were going on? So the buck may not end with this particular person. So it could span many countries. I think we've all had matters that started in country A and ended up in 4 or 5, sometimes many more countries. Siemens is a perfect example. But having local resources and understanding data privacy laws and what information can be taken out with investigations in China. I know we have to be mindful of state secrets and have sort of an extra set of review of information that might be taken out of the country. So there's a whole bunch of considerations, language, translation, et cetera.
Sally, the second bullet I wanted to ask you about it, which is, assuming the investigation is complete, what are the things you would be doing? You think you touched on this, steps you would take to mitigate the risk or this type of misconduct happening again in the future? Are there some things you would do?
Yeah, but it depends on what you find in the
Right.
course of your investigation. Is this a policy problem where you need to be changing the policies of the company and ensuring that you're training everyone on it? Or do you have a rogue actor here who you had policies in place, but he just wasn't following them? You certainly, I think, need to be looking at what your control mechanisms are, though, of how it was you didn't identify any of this but for a whistleblower calling your hotline.
And some of the aspects of what the Department of Justice looks at in terms of good compliance programs or things that are probably swirling around in your mind if you're representing this company, did they have, and we'll get to some of these questions in a minute, but something to think about. As you think about some of the next things in the next slide, one of the questions that I'm kind of coming back to is the self-disclosure. It's a huge balancing act, self-disclosure is, and there are some reasons under FCPA that Norm, you're familiar with. There's some benefits for disclosure. Let's assume there is a problem. Let's assume it's quasi-endemic, but only to the countries that this manager has been in, to the point that Ann was talking about, which is the Department of Justice does not expect you to boil the ocean on these investigations, and sometimes these cases turn into that, and they turn into a fee opportunity, perhaps more so than they should, and when the investigation could be narrowed for the client. But anyway, just curious about where you see disclosure, Norm, at this point in time.
Yeah, certainly you're getting to a point where there's more corroboration. I think Sally really articulated well sort of the thought process around it might be beneficial to sort of have that initial conversation. I'll switch gears a little on you, and maybe the other panelists can talk about whether to go into the government, or not. But also, I think of disclosure from our public filings perspective, as well. So I think you have to also be considering at this point, do you have a material issue, either quantitatively, maybe at this point you have some understanding of how significant these businesses are, how much is at risk in terms of your potential exposure for, say, disgorgement, or is it really, or even qualitatively material? Because if you're a company who is a multinational operating in outside of the U.S., if you have anti-corruption issues in multiple jurisdictions, you might make an argument that it's qualitatively. And then what do you do? Do you do an 8K so that you have to issue some sort of disclosure in between cycles, or maybe you'd feel comfortable doing this on a quarterly update? And I think that plays into the self-disclosure, because I believe that with most companies, if you were to go into the DOJ or the SEC, I would think that you'd probably have a disclosable event that you at least have to consider, a press release or an 8K. So the timing of the disclosure might be something that you want to think, hard about as well.
Anybody else comment on that?
It'd be difficult, I think, at this point to quantify the effect, right? I mean, whether it be a contingent liability under FAS 5, what's the potential disgorgement? Is there going to be, profits disgorged from these contracts, or what are the what are the fines and penalties that may be levied against the company by DOJ and SEC? We're often asked to do early case assessments. This would be, you could do a worst case scenario. You could take all these contracts that this manager was involved in negotiating in these 3 high-risk countries that they used to manage, or he used to manage, and try to quantify what that worst case scenario is. But I don't think that would get you to something that you would actually have to book on your financials.
And so these situations come up in high-risk industries. Oil and gas is one of those around the world. So PDVSA in Venezuela is part of an investigation by the Department of Justice. Pemex in Mexico has been part of these. Wherever you have government-controlled oil industries around the world, it's sort of an opportunity for there to be a problem. So that's one of the reasons we use this in this FCPA hypothetical. So you've got training is an issue around the world, and you've got different cultures, different languages, challenges that you may not appreciate, but in terms of incentives and goals and benchmarks, assume that with your compliance at UPS, Norm, there are incentives for people to be compliant and report problems, correct?
Yeah, I'd say it goes beyond incentives. I think there's an obligation to, sort of, we often talk in terms of see something, say something. So, identifying issues when they come up, is an obligation, I think, of UPS employees. In terms of the idea of incenting, good behavior, I think that's one of the harder things, I think, to incorporate into a compliance program. I think it's aspirational. I'm not sure I've heard, or if we do a perfect job, around that. We will find times when people do identify issues where we try to recognize them, for doing that. Certainly easier to mete out discipline, I'd say, than it is to try to come up with good ways to incent good behavior.
Right. So you want to push your culture out around the world, but sometimes you get pushed back, and there is some parts of the world paying people more than grease payments is considered culturally correct, and it's just something that we're dealing with. But there is a change around the world, and that's happening. And when Sally, you were at the Department of Justice, you saw a change in the world in terms of enforcement activity going on in other countries. Volkswagen's a case you really can't talk about too much, but and also there's no piling on rule that Deputy Attorney General Rod Rosenstein has implemented, which is if you have the French, for example, Société Générale imposing fines and penalties, and our country imposing fines and penalties, there's some sort of balancing going on now, isn't there, between the countries in terms of how those fines are imposed, so you don't get double fined?
Yeah, and I think there's always been, if not a written policy, certainly the spirit of the department was that you shouldn't be piling on. You should be trying to coordinate what the penalties will be with state counterparts, foreign counterparts. I think what you see now is that there is increasingly cooperation going on between the Department of Justice and the SEC and foreign authorities. And I think it's a helpful thing to articulate that then in a written policy to make sure that it actually spreads out and trickles down to the folks who are going to be actually handling these cases, that to the extent possible, and it's not always possible because from a timing standpoint, particularly with respect to the states, they oftentimes follow the federal actions, and you can end up sitting on a resolution for a very long time if you are then trying to apportion what the state's hit is going to be as well. But I think it's all sort of in the spirit of what the department's mission is and has been and will continue to be, and that's trying to seek justice and to be fair and to mete out proportional punishment.
And so, in a large part of the world is still not caught up with us in the United States in terms of how we approach, how we enforce things. And I know just related to this is just, companies from other countries around the world are trying to acquire U.S. assets, and I assume from time to time we're trying, maybe from the UPS perspective, acquiring assets. We're merging and acquiring. And Ron, this is something that you're working on a good bit of, I'm sure, in your work. You're looking at, I know later this afternoon you're flying to India, for example. Would you tell the audience what that's about? No, just kidding. But anyway, as a practical matter, what I'd like to get from you is the merger and acquisition piece. Is that something, and Norm, I want to come back to you on that and get your thoughts on it.
On merger and acquisition, I'd say we are doing more pre-acquisition and post-acquisition due diligence around anti-fraud and anti-corruption, more so in the last year or two than we've had ever before. I think a lot of companies are very sensitive to this. Obviously, there's limitations what you can do on pre-acquisition due diligence with respect to information that you get access to and people you get access to. But certainly, you get access to everything post-acquisition if in fact the deal goes through. And I think a lot of sensitivity around, especially if it's a company that's dealing with government officials or government entities in high-risk countries. And a lot of times it could be on the revenue side, but most, if not all companies are dealing it on the operations side, license and permits and customs and, other touch points.
And Norm, are there some benefits, following up on Ron's comments, are there some benefits that accrue to an acquiring company if there's disclosure about the problems you find when you're doing an acquisition?
Yeah, it's something we think about a lot. I mean, we operate in 220 companies, and it's a growth part of our business, so we have lots of, interest in, acquiring, companies to grow inorganically. And I agree with Ron that, we do have a focus on pre-acquisition diligence, and oftentimes we'll take companies off the table if there's any hint that there, is an issue. But you do have, I guess, the option of resolving those issues, say, prior to the acquisition, which I guess would be the best way to ensure that you thought that the thing was clean before you actually acquired it and merged it and then owned the issues. And to your point, there has been some recent guidance from the DOJ that they will work with companies in a similar way on self-disclosure if during the diligence process issues are identified during the diligence process, can be disclosed, and plans to remediate those can be worked out, I think, with the DOJ that would not necessarily create successor liability for the acquiring company. Similarly, I think if you were to acquire a company and then identify issues after acquisition, potentially disclosing and identifying how you're going to remediate those issues would at least mitigate, if not, potentially resolve the issues as a successor for, with the DOJ.
Thank you. And so that's the good news. And wanted to wrap up this hypothetical with one sort of last question to the audience and everybody on the panel. Feel free to jump in. Misguided information, perhaps, is if you somehow had hired a contractor to do your work. In other words, can you build in willful blindness? I guess almost in a way, if you hired a contractor to do the work and operate your Libyan operations, does that somehow insulate you from liability under U.S. law? And Andy, you have thoughts on that?
That would be a no.
Short
answer.
Hell no.
Okay, so
Hell no. Is that what you said?
so that's the road to bad outcomes. If you've hired a contractor thinking I can outsource responsibility for ethics in my company, ethics in my in the boardroom. So anyway, not a good idea, right?
No. And in fact, you have, I think, affirmative obligations to make sure you've got programs in place to vet any, contractors like that or third-party vendors that have, issue or that have contact with government officials. I'll also say that understanding how you operate can also impact your ability to do investigations and how you approach the investigation if issues, do come up, because it's often not as easy to do them when you're involved with, say, a third party that's working with you as compared to your own operation.
Thank you. Sally?
No, I was just going to say, in fact, the department actually expects companies to be even more diligent with third parties than their own employees, because it's such an easy way to be able to hide the payoffs. And so in evaluating compliance programs, one of the articulated factors for consideration there is what type of controls a company has in place specifically for third parties.
Right to audit. I mean, you have to have a right to audit, and I believe that you have to actually exercise those rights to audit in some way to be credible as it relates to third parties as well.
So we want to move now to our second hypothetical, and that is really addressing sort of the schism that sometimes occurs between compliance and the general counsel's office, and sometimes not. You're the general counsel for Fieldwell Pharmaceuticals, and you've been in that role for the past 8 years. Fieldwell has just come off a corporate integrity agreement with DOJ that required it to divvy up the duties of compliance and legal in 2 different executive positions in departments for the past 6 years. During that time, you very much enjoyed having not to worry about the compliance side of the business. This is to the general counsel. Since the CIA began, the chief compliance officer, Ms. Susan Goody, established a confidential employee disclosure hotline, developed new standards and policies, and formed a new audit team specifically charged with reviewing all payments to contractors, distributors, and physicians to spot potential overpayments and kickbacks. Despite this program, some company executives and board of director members are pushing you to reassume the duties of chief compliance officer in order to reduce cost now that the CIA has ended. key proponent of pushing these two functions together is none other than the president, Mr. Tone, who has called you every day for the past week to discuss the matter. And Norm, unfortunately, you're the receiver of this question because you're the only general counsel we have up here at the panel. So let me ask you, what's your initial response to this call?
I thought what I might share with you is how UPS is set up, because I do think that a structure like what's described in the hypothetical can work. And at UPS, we have our head of audit and the chief compliance officer are the same position. So the head of audit is also the head of compliance. And functionally, they report into me as the general counsel. So I have audit, compliance, and legal. Obviously, the head of audit also has a direct line into the audit committee, and that functions quite well for us. I mean, I really like the alignment with audit and compliance, because compliance, in addition to sort of owning the programs and the policies, the training, has the arms and legs of audit to sort of be out in the field and assist in training, but can also, do investigations at times as they're appropriate. But the thing I guess I want to emphasize is that also there is a lot of visibility, transparency, interaction between our head of audit and compliance with our board, with the audit committee, and then also with our risk committee, which was formed about 3 years ago, which handles our enterprise risk management process and also focuses on cybersecurity, physical security, business continuity management, some of the non-financial risks. So I think structured the right way, I think as described in this hypothetical, it can be work. But I think the key is ensuring that you really do have independence in that compliance and in that audit role. Maybe less important than sort of the functional reporting is there true independence.
So there's really not a cookie cutter response to these types of things. It really needs to be somewhat nuanced depending on the corporation or business. Is that your sense, Sally?
Yeah, it is. In general, although I think it would be incredibly stupid in this context, coming off of the CIA to then go poke your finger in the government's eye and say, we're going to go back to doing it the way we were doing it before, when we obviously weren't doing it correctly and got in trouble.
To save money, right?
Yeah, exactly, to save money on top of all of that. So absolutely agree with Norm that, look, I mean, certainly the thinking out there is that you ought to have sort of a separate compliance and legal, and never the two shall meet. Realistically, though, as long as there's sufficient resources for compliance, that they have enough autonomy, that they have access to the board, and that you're not literally merging the legal and compliance functions, which you're not doing at UPS. Right. I think there are different models that can work. But in this instance, as soon as this expires, to kind of go back to the way you were doing things seems to be a foolish step to take.
And so you're being watched pretty closely if you just come off of CIA. That doesn't mean that that's all behind you. And
in a highly regulated industry.
And if we're talking about healthcare, which I'm guessing in this room, a large percentage of the lawyers in this room work on healthcare-related matters, defending those cases. And so I wanted to turn, Ron, to you in terms of your reaction to this and your experience. And again, this is a nuanced area, isn't it? It depends on the company or business.
It does, and Sally, you said resources, and I think that's absolutely right. I mean, compliance. The compliance function is so much more elevated today than it was years ago. And just think about all the rules and regulations, whether it be trade sanctions and money laundering, and it goes on and on, anti-corruption, you can keep going. So the level of expertise and the knowledge and the resources needed to do a diligent job in compliance in a highly regulated entity is just enormous. And as long as there's the resources and expertise, it can certainly work.
Ann, any comments?
Yeah, I think one of the issues is what is your initial response? And I think that when the CEO and members of the board are coming at you to change a structure back to a structure that didn't work, I think one of the initial steps would be to remind your CEO and your board where you came from, and maybe rereading the CIA might be a good first step. And like you said, is it possible to construct a process where it would work as a combined unit? Yes. But under these circumstances, it obviously didn't work 8 years ago, 6 years ago. So I think the tone at the top sort of permeates this and all of our hypotheticals. But this one is really important to remind the CEO of the company that tone at the top has to be focused on compliance, that the money part has to take a secondary role. So I think just sort of remembering the history of how you got to where you are, reminding the board of that would be a good initial step.
And so in some of the cases I've seen, there is a taffy pull sometimes between the compliance officer and the general counsel and the audit committee and you name it. It just becomes a fractured prism of different interest. And I think Mr. Tone is, by not appreciating what's happened historically, creating more problems for the company than not, probably, in my view. So tone at the top doesn't work in this situation. So I think we've answered some of the other questions in the hypothetical, and in keeping with the idea of moving to through these hypotheticals and then leaving a little time at the end for questions. I thought I'd move now to something that's really been in the news a lot, which is the companies that have had breach issues, hugely financially challenging for those companies. And some of those are in the news here in Atlanta, certainly Equifax, Home Depot, Target, all those companies have had problems. My personal data and information was hacked by the Chinese, so my SF-86 is somewhere in Shanghai right now being looked at. But anyway, the point is, even government entities are vulnerable to information being stolen. So the hypothetical is you're the general counsel at a publicly traded technology company called We Make Apps, which is headquartered in Washington, D.C. The company designs an iPhone application templates that can be easily customized for restaurants offering food delivery services in the D.C. area. For example, We Make Apps design the application templates that Madison's Pizza and Monroe's Calzones used to create their iPhone delivery apps. We Make Apps iPhone application templates allow end users, that is, the customers who are ordering food delivery from restaurants, to store their payment information in the application. To store the information, the end user must consent to share his or her payment information with We Make Apps. Sounds really familiar from the current news, right? The data is then stored on We Make Apps cloud. Since its founding in 2010, We Make Apps has become the preferred iPhone application template for restaurants that several Supreme Court justices, well, maybe some new ones too, Jay-Z and Bill Nye, the science guy, used when ordering food in the D.C. area. Over the past 2 years, We Make Apps has received frequent false claims about hacking and phishing end user payment data stored on its cloud, but fortunately none have proved to be genuine. You appreciate that you have numerous obligations to the people whose data you hold under both federal and state law. In fact, you take several precautions to keep the data safe by using encryption, deleting the payment information after it's been stored for a year, and only transmitting the data to the payment processor. Yesterday, you received an anonymous letter via snail mail threatening a complete shutdown of We Make Apps computer and cloud networks and threatening to publish all end users' payment data, including data belonging to Justice Ginsburg, Jay-Z, and Bill Nye on WikiLeaks. However, none of this will occur if your company pays $10 million in bitcoins to the anonymous blackmailer. Nightmare scenario, right, for all of us, and I guess the first person I would call would be Kurt Erskine to say I've got this problem. But anyway, there is a part of this, which is who do you call in these situations, and you do reach out to individuals and stakeholders. But let me turn to Norm, you again, and sort of the first at bat to talk about this topic.
So I think in this area is more maybe than anywhere else because of the sort of all the headlines and the companies that have had issues. You really need to have an incident response plan. So every company should. So that would be the first place to go, is the incident response plan, and identifying internal stakeholders who'd be critical to sort of understanding the facts around this particular incident, trying to validate whether we really do have a problem. So that would typically be legal, information security, our CIO, the CISO, Perhaps, depending on whether, because again, it's not unlike the other investigation, you need to assess, I think, do we have the internal resources that would be able to start understanding what's going on? Or would you want to go to a vendor that you probably should have on retainer to be able to do, the forensic work around those issues? Perhaps PR, types to start thinking about messaging in the event that this turns into, but I think that would be the first step, is to engage that incident response team so that they can begin to assess the situation and begin the investigation, and also consider what escalation, needs to happen once you start to understand the facts.
And maybe it's almost a fiduciary duty with all the information that you might have in your possession, some companies. So I wanted to kind of turn this to the rest of the panel to kind of get their thoughts on it. A lot of personal information and personal data is held, right, Ron, by these companies?
Yeah, and by the way, this could be an inside job as well. We can't assume this is an external party. It could be someone within the organization, and we've had, certainly in our organization, internal investigations to make sure there weren't data leaks, especially with sensitive client information, and we have pretty robust processes around that. I can tell you public relations would certainly be top on the list. I think the kiss of death from a PR standpoint is to go to the public and say, assuming this does happen, let's just assume you do have a data leak, and say, well, there was 10,000 accounts that were affected, and then 2 weeks later say, oh, sorry, it was 100,000, and then a month later saying, yeah, it was 1 million. You want to get your arms wrapped around this pretty quickly and get the right level of expertise. And I can tell you, whether a company pays or not, and I think, Norm, you worked this out to some astronomical dollar amount, but if it was a lesser dollar amount, I mean, I think that's the risk profile of the individual company, and hopefully you have that worked out before. I think the rule of thumb is law enforcement prefers you not to make these payments, but certainly companies have different risk profiles. I know healthcare organizations that this could really cause enormous harm to the company have paid, and others haven't. So it's an individual decision.
It seems like having a plan, and let me get to Ann, I'll come back to Sally.
Well, I just wanted to, just like in any situation, you want to look at the facts that you have and to see what's the scope of your, obviously you're going to initially go to IT and do your internal, triage. But you're looking at this, I'm looking at the facts of the hypothetical just for things for your practice pointers. You've had numerous false claims in the past, so I think that puts you, you have to be able to discern one from the other. The anonymous letter came via snail mail, which in the cyber business would be unheard of. The use of snail mail, I think, would be something that would put you in the, maybe it's a hoax column. The 10 million Bitcoins is how much?
Yeah, it's like 70 billion.
So $70 billion for your food delivery service. So I mean, I think that, the bigger picture here is that these attacks do happen, but I think there are another reason to go to a vendor who would be able to help you identify those facts that may lead you in scope of what are you looking at here.
You do get, I mean, the reaction is you obviously get your IT folks, right, your internal folks to maybe take the first stab, your CISO. Is there a potential conflict of interest? Because if there really is something happening under let's say my watch as the CIO or the security officer, how diligent am I going to be with exposing potential things that happen under my watch? And so we've seen combinations of internal and external resources to run this down to ground.
And so,
And I'd
Sally?
just like to put a plug in for calling the FBI. And, I get the reluctance to do that
Right.
for a variety of reasons. Once again, you're asking the government to come in and root around in your stuff. And it also has the potential that perhaps you didn't have the security mechanisms you needed to have in place. And
Right.
that's not, doesn't feel all that comfortable to be calling law enforcement about that. On the other hand, they are very experienced not only in dealing with companies in these uncomfortable situations, but this has a chance of looking very similar to other incidents in which they have encountered and can tell you whether it's real or who it would be. I mean, there is a repository of knowledge and expertise there. that you don't necessarily get even with the best outside forensic people. I don't think that means to the exclusion of your own outside forensic people, but you sit around too long and you don't call law enforcement and you do have a disclosure issue later, you got some explaining to do about that too.
Absolutely.
When you are making that. And then I guess the final thing I'd say is let's assume it wasn't $70 billion and the company did decide to pay, which there are circumstances to do that, but I actually think they're pretty limited. Just because you pay doesn't mean that that data hasn't been exposed and you don't have the same disclosure obligation to the consumers then. And so I think you have to think about that too. That means the company still has the data, assuming that the bad guys make good on the deal here, but that doesn't mean that the data hasn't been exposed. And so I think you've got to have that forensic analysis to know whether there's been an exfiltration and what's actually happened to it.
Can I make on your point about law enforcement, it's also part of the preventative, piece. So certainly after it's happened, it's a consideration, but trying to identify sort of relationships before is really critical as well, because we've also had that. Sometimes when things happen, you end up getting bombarded with different constituencies, maybe different offices, it could be different places. It's really nice to have a relationship developed with maybe your local law enforcement, maybe the cyber, experts, here in Atlanta, or could be the U.S. Attorney's Office, whoever you choose to work with, so that when something like this happens, they won't be hearing from you for the first time, either, and that also can build a little bit of trust that they won't overreact in terms of how they, engage with you, as well. So that's part of the preventative piece of this, or the planning, just like with the incident response plan, and practicing that with data breach drills along those lines, so that you've got some practice in implementing these things before the real thing happens.
So it's really important to emphasize that. My firm does a program with Georgia Tech called CyberCon, and it's sort of an intersection of those types of things in one place. It's a good opportunity to have those discussions. And Steve Grimberg, who's with Nardello now, but was with your office and did cyber there, and I have gone around and sort of preached the cautionary tale, but to the point you made, Sally, reaching out to the FBI and Secret Service, it could be something as simple. It could be simple things. Somebody's hacking into a system that, it's something that's been seen someplace else, and there's an easy fix, right? Some sort of patching that could go on to the system. We may be preaching to the choir in much of this. You may already know this, but it's important to think about it. And the Secret Service at Homeland is another part of the equation. And so things that happen with hospitals, with medical devices, those can be hacked into. And some of my clients have been contacted by DHS saying that there's an issue we believe is happening with some of your systems, just to put you on notice. And so but I guess the big takeaway, at least on this one, is make sure you've had those contacts before you have an event. So your security people are in touch and they know people at DHS, the FBI, U.S. Attorney's Office, and
Joe, I also think importantly that the FBI or law enforcement can help in if there is a breach and there is a contact that's made with the ransomware bad guys, that the FBI can help with that communication. And if there's a negotiation, can help with that negotiation, which gives you good cover and how the issue is ultimately resolved. So there's a lot of good reasons to go to law enforcement.
Yeah. And of course, the plaintiff's bar may be represented in the room, but nonetheless, it's important to know that there are people who are, drafting lawsuits immediately once these things become public against your company in class action situations. And I think what we talked about, Norm, and everybody here has been really these preemptive steps can reduce your exposure in those situations where you might have a class action or other exposure, correct?
Yeah, I think so. And just put you in a position to be able to react to which vendors to use, things like call centers, credit monitoring, the outside experts on the forensic side. All those things really do need to be in place so that when something happens, you have the ability to implement the plan, as well. As it relates to, to sort of liability and lawsuits, I do think there may be some ways to mitigate, with credit monitoring, if you could, avoid the economic harm from that perspective. There may be some other things you could do, I guess, with class action waivers or arbitration provisions, things like that, maybe in terms and conditions.
Well, these have been the three hypotheticals we put together. We had hypotheticals 4 and 5, and I think maybe 6. But we thought Friday afternoon it would not be a fair thing to do to you to put you through that without giving you an opportunity to ask some questions. And you have a great group up here, some outstanding leaders in the legal field and accounting field to ask questions of. So as you think about what you've heard today, does any of this suggest that questions you might want to ask to the panel? Let me ask anyone. Okay, everybody wants those free golf tickets, so we could go right to that. Have we gotten everybody? I guess everybody's cards have been inserted into the bowl, hopefully. As I think about this whole area, sort of some concluding thoughts, and I'd like to get sort of a roundup from the panel, some final words on this, because what we had intended to do earlier was to maybe go panelist to panelist to panelist with some opening comments. We felt like we should kind of go right into the hypotheticals, but as we wrap up, I'd like to hear some closing words, because this as we close out the program is probably sort of the pièce de résistance, is the how, since we're at Chateau Alain, is to think about this as the coup de grace, if you will, for companies, is if you don't have in place a good culture. And Volkswagen apparently still is struggling with culture. The Larry Thompson's reports on Volkswagen have not been necessarily laudatory. So they are trying, it looks to me like some people in Volkswagen are trying to find ways to work around Larry and his function as monitor there. But that's just my opinion, just an editorial comment. But as you think about this area, it's probably not anything more important in the long run for the health of our country than having people in our companies and businesses be ethical and oblige corporate governance. And I think it can cause narcolepsy probably when you hear me talking about it, but at the same time it's important to think about this. And I know, Norm, your company really does value corporate governance, right?
Absolutely, and integrity. When I was looking at some materials for this panel, I saw there's a quote by Warren Buffett that I'll share. It said, "In looking for people to hire, you look for 3 qualities: integrity, intelligence, and energy. And if you don't have the first, the other 2 will kill you." And I thought that was kind of a cool way of thinking about how critical sort of integrity is as part of the culture and the value proposition for most companies. The other statistic I saw, which is pretty interesting, of the Fortune 500, more than 100 is like 133 don't have integrity as part of their core values. I thought that was fascinating, as well. But clearly at UPS, I mean, that is sort of the centerpiece of our culture. If you think about our business, even we're the trusted broker. People let us into their facilities. They let us carry their goods. They let us, understand who their customers are, interact with their customers. If we lose that credibility with our customers, then we wouldn't be in business, very long. So it's a very important, part of what we do. And I think it'd be a competitive advantage for companies that place integrity, high on their list of criteria for their employees.
Absolutely. Sally, any kind of close thinking on it?
Just briefly, I think, even in an organization that values integrity and identifies it as one of its core principles, bad things can happen. You can have an employee or employees who are not operating the right way. And I think, from the government's perspective in the years that I was there, and confident it still is that what they're looking for is to determine, is the bad stuff the way the company does business? Is that who they are, or is this aberrational? And that's reflected in a lot of the different things we were talking about today, and having a compliance program that's real, not just on the shelf, but is actually interwoven throughout the culture of the company. How the organization responds if there's an incident, whether it's a cyber incident or otherwise, and how it interacts with the government if you are in the unfortunate position to have an incident happen where you have to. So I think, the government's never been looking for perfection, and you can fiddle with policies, but at its core, I think it's still trying to ascertain who is this organization, how do they do business, and what's going to be a fair and just result. And so if you're in a position to be able to demonstrate that this was aberrational, it's not who we are, it's not how we do business, and we've addressed it, then you're in pretty good shape.
I would say that over the course of the 27 years or so I've been practicing law, that the Department of Justice comes out with new guidance or new memos and things like that and speeches, but the core foundational parts of corporate compliance have really remained the same in value, and that is respect for ethics in a company and in a company's ability to demonstrate that. So even the nuances that come out, they're really shining the same thing. The risks change. 20 years ago, there wasn't a cyber risk. The risks change, but the way that your client companies operate really has remained consistent over time.
So a couple of major learnings for me. So from my investigations, in most cases, the company had kind of best-in-class controls and compliance programs. I can start naming them all, but you know what they are. But something significant happened. So how is that possible? I mean, of course, you could always have bad actors. A couple of learnings from my experience. So number one, we talk a lot about tone at the top, but for most people in the organization, their top is a plant manager, or their top is a country manager, or their top is a regional manager. They don't know the C-suite. They don't know the board. It's sort of like undercover boss, right? You don't really know the higher up executives. So how is that tone permeating through the entire organization? And people in organizations face real pressures. So the Turkey investigation that I was telling you about, the manager who was responsible for Turkey had an aggressive sales goal to grow that business, and she had a 3-year plan to grow that business, and a lot of the customers were government. Turkey was going through a recession, even though the U.S. economy was doing quite well, and she felt an enormous pressure to give huge discounts that corporate would not give approval for. So she used a third-party vendor to route money out of the company through the third party to the customer. So it's a round-trip transaction using companies' own money to honor that discount. She was using creative ways to meet her goals. So we had a bullet point on the previous slide about incentives. How are your managers being incentivized? Is ethics and compliance part of the program, of what their goals are and how they're compensated and ultimately disciplined? Learning number 2, when it comes to compliance programs and controls, is trust but verify. Test. We have some clients that do anonymous surveys, get the pulse of the company in different regions about their knowledge of policies, procedures. Do they feel comfortable coming forward with allegations? Are there any concerns that they have? So on and so forth, a whole series of questions. And when you start peeling the onion back, sometimes controls look really, really good on paper, but in reality, there's weaknesses all over. Again, our manager in Turkey, there was some great controls about purchase orders. Anything over $25,000 had to be approved by the regional manager. It's a great control. Any third party that you have to use has to go through third-party due diligence, a great control. The weaknesses in the control was, for the purchase order, she could structure them under $25,000. So she had to get $100,000 out to the vendor. She would do 5 purchase orders of $20,000 under the threshold. If you did some data analytics, you would have seen it. You would have seen these anomalies of these structured POs all under $25,000 to the same vendor on the same day for the same description that happened to add up to significantly more than her signing approval. So data tells you a lot of things if you're looking for it. So test.
Okay, that's perhaps the final word for this panel, but before we move to adjourning, I want them to get a great round of applause, but we'll have our drawing after the round of applause. So let's give them a great round of applause. Thank you.